Okay, kon pangya formal takina. Nabe kun paite academic forum aake par ni takha nabe kun kay grace don nimching paite academic forum sigletangan vaidon kahi. Paite academic forum ichikha two lelela atam kha 2021 to 2024 waliya. Ya kha two lela membership ni songbuk lekhat ahiya. A members dekha research scholars ahi kele teaching field academics mun tuam India ale outside India ale member tuam ki umkom ahiya. Hai forum in atupu discussion ahi kele banga igamle namthu ahi kele mabana research topic apoimo a research topic to kitsai ahi kelele I banga new research ideas ti khong kilungula hi chianga hai paite academic forum kha ong ki putahiya kati ma banga December 2021 a ki register ahiya tu nya hamhat wai akisama ma a laka I resource person de thotak Dr. Thangzakhup Tombing welcome ama hile introduction kha ama kha CV sawain sin tomchi kan gen dikahi CV teng gen don dong leng kha dakar khat bangong lut mai the hwai jaka CV ku kon cut short dia tu lela ma kha assistant professor rahiya National Law University and Judiciary Academy Assam ama kha LL.B DU ki padzawahiya LL.M from Jamia Millia Islamia hwaya kha gold medalist rahiya Wailo tule lakha makha administrative level public information officer at National Law University Assam hai post len lelahiya 2017 kipat. Wailo ama I tomchi kon gen lai dia ama kha I hai ilam to hai la mali akwa ini situation me ni thuma kipat ibuai kha on effect mama insin why to kisaya ha a legal aspect lam him expert banga on haile theidi kide in chen ama kha I kipal taka iwa banga iwa zottu nga kha aman kha ong onamen pa in chen wailo Dr. Khup naman chiang ina on hileu chin hai to khat banga I organize him diu cha akidob bol man kha no naman na kwalike ongki man sagdi ke man di kahi on che hiya it's a resource person ki phaltak inei bangle ham phat wai isa tuna Dr. Kupha formal katin welcome kina ipan paduwa tu like situation so kito na kha akwa kha Keibang telina kekha I have a very little knowledge of law kekha law chi ABC le thailo why zaka banga tunya ong tel bang le ahi ke long tel man lo why na zaka ong tel man lo tel le there are certain issues which have been bordering us why zaka Dr. Khup kya nga kha ama sapena kon do tu chu zalam se ka kha May 17 Supreme Court in kha second hearing on Pia Insin. Supreme Court in kha it criticized HC the High Court of Manipur order saying that it was factually wrong. Why hi chiang kha hai tung tanga kha banga what does it mean by factually wrong in next step pukha banga bangchida napan lagdi ahi kele what are the various banga issues that we have to keep in mind sikha ina non elaborate thiam Dr. Khup
ole kipake for the wonderful introduction and the welcome to hai query pen kha ithei samna dina PowerPoint presentation lejang kom dewa ong ki pat na kha new kha suijek bang hile echana dina me teitin hi tu line hi revival chi khat ananewa revival ana chi now chu bangyam chi chen hi koi tan hiam hi kang le pak revival hiam ai ke le ni danga a glorious meitei kingdom pai khong new kha ngai tua kong le thil dang dang ahon hi dek chan hi e bang chi tu kina superiority complex nei kha bang hiam hi leu le hi e leitang ahon nei lo chan hi hong tang thei kiwa plus Eimi hiam sing tang mi him Manipur hi 371 C jakina le British te hun lai pada excluded le partially excluded concept te nom khak jakina le 1935 act le waima ana paito na wana independent India bangale wana constitution 1949 hongomin le hi value system ana paito kha au chi chang ni ahon ngai to chana bang chidana en Manipur kha e e Manipura gamle Manipura resources te bang chana access the di chi chani the only way out was going for a ST demand why dan ongi kha why jakin hi mutum churamani meitei versus state of Manipur yai hi a case loisi mahia hilele kumsom kong paita case ana file hia writ petition noi khata ya hi single bench justice Murali Dharan in hi acting chief justice in hi meiteite argument hi ana pompia wana meiteite hi landlock tema wana amau bangle tribe civilization dang to cut off sima omahi naule features dang dang on the chani st ma hiu china ahon observe saka wana article 41 le 21 noya constitution of India noya right to equality and right to life in the context of dignity of life why interpretation in Manipur High Court in Manipur government and a director khathum kalni kalthum sungina yai ST recognition pen hi a process and a pata ana apoimo dang dang constitutionally or otherwise why te hi dia a order and a piak ahia why order hon piak chan hi hiya a issue ngom non chu sing tang mi ten hichi bang order ngom chan hi sing tang mi te right constitutionally protected right te hi me te anna advance zo communities ten delam cha ahonna subsume homvek khakwa in terms of right to access to education le access to equal opportunity to jobs why affirmative action te hi hon su boy khak di chi lau ja ke ni dinganglung gangmei retired IS le hill area committee chairman ina special leave petition Supreme Court article 132 noya ana peluda why he Supreme Court judges 3 judges bench Dr. D.Y. Chandrachur PS Narasimha le JB Pardiwala writing a special leave petition pay on the merit of the case in anna entertainwa why he a court in he unobserved chu to why a case hong pai honki hurt takin hi Manipur hi mei ni thumle mei nili sangni le somni le thumin hi mayhem anna omhinta why he imphal banga Eimi singtang mi te ana boldan te upang le adang dang te bang le Supreme Court ina ana thei pi banta why jakin hi huchi bang status report te hi on it chani Supreme Court ina it's a humanitarian crisis achia why jakin hi Supreme Court expressed its concern over the loss of human life and destruction of homesteads and places of worship china the court emphasized that there's a need to ensure that due arrangement are made in relief camps and providing all basic amenities in terms of food and medical care. Wana rehabilitate internally displaced mihim yai law and order breakdowns ya ka khate hi wai te rehabilitate didan le biakin kongan ki hal sel wai manina wai te bang chidana protect it china observation anabola while wina a Supreme Court in observation kat anna bol non chu bangyam chile High Court in Bangchidana yai scheduled tribe recognition pain Bangchana aman ana direct hey mok china High Court in Supreme Court in High Court admonisha as yagbel a state of Maharashtra versus Milin and others kichi judgment nahi Supreme Court in he yai observation ana bolsa here as per relevant constitution provision of the Constitution of India, it is only the president which can give an order for recognition of tribe China, anna admonisha. Ahile via a first hearing hit non in he 17 May hearing on nei nona. Yahi SLP second hearing pain ong inona via second hearing pain he Supreme Court in crisis omte le status report hon chan hi FIR ki file le adang dang hong te ahon ngai sunona why jakin hi ya observation dang khat Supreme Court in ahon bolnon chu bangyam chi le hi a High Court order pen kha a High Court order pen kha a stay sakthi hi chi chu Supreme Court in le athea because then state of Maharashtra versus Milin case bena Supreme Court in a observation le apaididan constitutional provision ana studia apaididan an again call hit penny a High Court in a subway hai jagina a quash le quas stay le state here hilele bangyam cha stay ka bang hilehi a Meitei community Tena dena revival in a GIY ST status on demand from that ST demand their aspiration with regard to access to land etc. Why pin hong subway kanon dijina so in that wisdom it made this observation that yai pin hi kumkhat delay defer bangile oh izodia machia hilele ya Supreme Court in an again non chu bangyam chile a petition penny pending darina akoya as jagbel any kind of grievances from both sides bangyam cha it requires immediate hearing and immediate attention of the Supreme Court of India a hearing om theina din china Supreme Court kongkhak te hi echa ana hong sak lai ahia why jakin hi meditian hi hi amau interview bangit lei judicial war achizenwa why jakin hi zo te tum tumahiwa zo te na diun hi amau bang le hi legal team bang hoitagina ana kisawa hile haikom kala hi ithe diu chu constitutional budan waya hi provision for recognition of ST hi article 3 okay ithe the poimo chu constitution waya hi article 342 hi a constitutional provision for recognition of ST chi anoma the president may with respect to any state or union territory where it is a state after consultation of government thereof by public notification specify the tribes or tribal communities or parts or groups within the tribes or tribal community which shall for the purpose of this constitution be deemed to be scheduled tribes in relation to that state or union territory as the case may be. Article 342 OMA. My pen close one here. Article 342 close to Parliament may include in or exclude from the list of scheduled tribes specified in a notification issued under Clause 1, any tribe or tribal community or part of or group within any state or tribal community, but save as the aforesaid notification issued under the said clause shall not be varied by any subsequent notification. Article 366(25) ahi. Scheduled tribe means such tribes or tribal communities or parts or groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribe for the purpose of this constitution. Why is again implications of Article 342 jichani? The President under Clause 1 of the said article may with respect to any state or union territory wherein it is state after consultation of government by public notification specify the caste, races or tribes or parts or groups within the caste, races. Race kichi then Article 341 schedule caste no race concept anoma. Hilele scheduled tribe no race concept anom ka hile yaipin hong anya yon sim hom chani races or tribes china yaipin ahong kila home here why jakin hi ite due to dena Milin state of Maharashtra versus Milina Supreme Court in and again to Bayam Chile. Parliament alone is competent to include or exclude a caste or tribe from list of scheduled caste and scheduled tribe here. Why jaga process of recognition pen ihon etian hi bangchidana honki recognize the ham chi tian hi the list begins with the recommendation from the respective state government, which are then sent to the tribal affairs, which review and sends them to Registrar General of India for approval. And this is followed by National Commission of Scheduled Tribe approval before the list is sent to Cabinet for final decision. Why is that? In again kaku inherent power of Supreme Court of India pen bangai chichani Article 141 ahi Article 141 ahi Supreme Court in a case khatpeu an eta via case a judgment an apyakhya khimim hi why pen kha it shall be binding binding to all the states within the territory of India here. Mana Article 142 chiomnona Article 142 penahi bangyam chilehi Supreme Court in the interest of larger justice for the petition that comes to the Supreme Court, let's say special leave petition bang, by a larger in the larger interest for the greater idea of justice a original jurisdiction bang le analathe here why jakeni he Supreme Court inherent power he Article 141 le Article 142 bang ahongom no na why jakin to here dena Manipur High Court in anna direct pen Supreme Court in he overruled in a power ane why kya lo ina stay na power le ne here hilele a law and order situation pen Supreme Court net jana in its wisdom peace le dang prevail the zona di nai Supreme Court in he it deferred the findings or the observation of the court for 1 year GI.
Utsile Dr. Khup. Undo tuju e Supreme Court in observation ka factually wrong achi in a way my simple understanding is is it a sense of a little achievement that we have been able to approach the Supreme Court and Supreme Court in its observation on Nethechu na ha mga sense of achievement akipa why lamin ilat hediam
yai pen kha kenchu kanamuda ni na. If you start celebrating too early, you might have to face banga lamet lopi dana le thilong pai the aziabel denagagen ma banga metite idea of revival kha. It is guised in the idea of a ST recognition anahia. Why it is guised in the recognition of ST GPN. Amaule, there is an attempt in among the society that they have to amaule hi why amau historical pasta sing tang mi te sanga thu pizo hi chi pen why pen ki overlook saka sing tang mi te perks le protection ne te why te access te na dia ST pen dinmun hoizodana honenwa plus idea hongomnon khatsu bayam tile why ST hi 9 80% 90% of the other land of Manipur where footing ne the na yam access ne the na yam why da na hone to chana and then the first step that is to ensure they have access to those land is the recognition of an ST tribe. Aung hi jakin why lo ale dena 342 ihon sim chani a process penyon ya cha dena a recognition hong pai dinan penyon ya chani state in state khat nei to nei hi ja kun hi hi case hi argument pen if they are able to argue that they in fact has features of being a tribe and then there is a topographic landlocked narrative if they are able to assert and say that they have all the features of being a tribe, though they might be advanced when compared to other tribes of Manipur, but they are not necessarily advanced when they're compared with mainstream India. High argument pain, if they are able to put forth, then it's not necessary that their argument may not have merit in the eyes of the Supreme Court. But the High Court,
to again to Supreme Court case pilal to mo ke ka Dr. Chinkandun wite kai tonza to kai am the siaman la to kha zalam ze ka Supreme Court dena Dr. Grace and again ma banga Supreme Court in kha it's unconstitutional cheve mo Supreme Court on the other hand, they did not strike it out. Strike down.
Yes.
Why cut question nina? But strike down lo ban waka I bangkat. Tuaka a 17 hearing aka I High Court lama appeal lo mahi mo higher bench appeal lo mahi why jakin alam vahi on sinon mo. So there are certain things at play in kamua mo na hile. Why then again mabanga tun as a representative from TFD neotik matong de wahina kha information kimu kha midangi bamu chianga kha tun adia kina home minister bakimu mo ai kele residual law and order minister hi lai kha bakimu uchi hi le amau khan again piu banga ai chi le amau 2000 years of history ne hukum pida na mo wangzia kama estimu dia kingta wangzia ka no bhai on chiwe chu wangzia ka criteria fulfill lo wa hi chiwe mo why ka on gen why pen if we take it as face value why pen khongza kha khen khat de kha complacent hi kha la ka adia kina tuna Supreme Court pursue di bangle khen khaten uchitela ba hi ngai no na ya china High Court bangle china mau hi hin hi wen la si sugle chi polom hilele Colin Supreme Court lawyer pa pin wine kha again kha uchana koi mo decision den cha a favor lo lama pai nge le den cha ma ba na pursue hak sa dei chi khat na mon den cha na ni bang zia ka wa di ko lo thei lo kai chan na bayon gen alo thei lo hi di chin amendment petition as ya petition pia kun kha ya previous judgment de bang ma sai tom lo it's just an emotional rent to petition on pin kha why is that amendment petition pia in hopefully fifth sixth here mo hearing mo kha fifth kha hearing de pai di we mo Gonzales Colin in kha ke ma ka pai de ka argue di chi ai ki pa why but that's a significant spin kha den chanon po kya thile de wa di khat na ni na why is it lama kha of course I have been criticized and people call me all sorts of things for that who ya MP Ranjan to MP Loro meeting sapna vatel khapola katela why interesting ma argument khat ong do khatomai chu any thei lo mo any in a consider problem kha me te ten kha to na ga te bang chitu ka bezo wai chi le kha amao kha aline chu kha na ga su we chu
okay
mo ong do bimola ko examine kha on gen le keile na ga kapu ka pa ui kapu lam te na ga te hi on chita cho then an hon gen tong ki tuak sim if they have a means to argue in spite of being advanced
hello then again ka yai pin kha to it's na demo ka slide ki mutheya special leave petition chiom ya
yes SLP
SLP ka article 136 akom ya mo constitution no ya ka ya apoy mo khat omchu the appeal can be made in case where substantial question of law is involved and where gross injustice has been observed more. The judgment, decree or order against which the appeal is being made must have character of judicial adjudication. This implies that purely administrative or executive order or ruling cannot be a matter of appeal. And further, it's also important that the authority whose judgment order is being appealed against must fall under the definition of a court or a tribunal. Here pin kha Supreme Court kha dena article 142 yam kongkon gen mo implications yai chu me tetin kha yai argument hon gedu changa if you study it from a unbiased and an external observer, it's a non-study changa. We have been limited to 9% of the entire territory of India, and plus in the hill states have denuded their forest more. Then they have not been able to protect and preserve their forest, their flora, fauna, and finally, when those protections are not made, the ecosystem is going to collapse and it's going to affect the value, the valley ways of life. This is one argument. Well, another very strong argument, Katka, poppy plantation, thousands of acres are being used for poppy plantation, and the process of poppy plantation involves a use of fertilizers, etc., which actually affect and impair fertility and the environmental aspects and ecological aspects of the land chechu. Why hon argue no chu bayam chile why popium ke plant changa fertilizers le weedicides on zatiun hi alei tegon so se diwai changa and why alei a toxic te hi atuite nek nong ludi which changa there would be a drastic change in the ecology hon chu changa. These are very convincing argument hongino nechu. While they being landlocked and then their culture seems to be diminishing and then their population seems to be diminishing compared to some communities of Kuki Chincha, a census banghon at Teuchanga. From a very external observer point of view, you being limited to a 10% of the land and then the 80% or 90% plus land are being not necessarily well protected, and as a state and who wants to protect and preserve the flora and fauna and then the pristine features of the forests, etc. Why don't you net janga? Somewhere maybe if the Supreme Court believe that there has been grave injustice being done to the community, haipin to haya a violent to make low banghile. And if they argue it strongly and then convincingly with historical records of the British Tenka tribes are unrecognized and those records are there. Why pain? If that if that argument is advanced and impactfully advanced, and if it creates doubt in the mind of the Supreme Court judges, then the Supreme Court may not necessarily say that the rights that they have been asking for does not merit a case does not merit a hearing. It's not necessary that they'll say that. Why Zaka Eilamin dena Dr. Lunian again mabanga. We cannot simply sit back. We have to prepare our argument. We have to prepare a legal team. We have to think for maybe the worst possible outcome also. Laid back te ilo mo. Why Zaka Eimi te argument Khadomsun Sunchu, they have a civilization or kingdom dating back AD 33, which was very much thriving, and they have the Puyas, the ancient text which talks about culture, religion, administration, etc. So therefore they have their own manuscript and they are very advanced in compared to us. Why Zaka the Assam banga, if there can be a plain tribes in Assam, there's a possibility of plain tribes in Manipur, and there can be hill tribes in Manipur. Yai pinchu hitayeve koitanyama mo. If the cases is argued with passion and then with very good preparation, it's just about maybe time that the Supreme Court start listening to these arguments. Why don't they?
Amauchu may they tend to research with Takana Bolwe, I demand ahi now more. I mean, the way missile da night some kapumo like this, yaikahiu. Hilele, Aloile, I think he complains on Gingtak to Kaka, we have not been Banga kileb on a kilade bag low aging tak to ka elle we could they took them to court and we could argue. So in a way, we cannot celebrate it too early. We have to be pilbang di. Yaitan ina Supreme Court ruling to all ina we will further elaborate on that. Dr. Khoop, another burning issue chi diya kalungsima omchu Eiloika tu laita ka 371C noyaki ominsin. Adikya?
Dik.
When we are talking about separate administration, to Assam Maleka Bodo Territorial Council omivoi. Waika Huchidandan inka Eiloi Iomte Diwam, and when we are talking about 244A, does it entail separate administration? As yakchu tu laika Eiloika separate administration kichi engine. What is the separate administration? What are the various features and characteristics? As yakchu haika banga thia thenga in kaginga mo. Can you throw light on this?
Ole. Sing tang mite concern ka historically bangin lehi lama historian le philosophers le political scientists na ahoy the mama diwa partially excluded concept no ma wana Bengal Regulation Act le no na wana 1935 Act ko bang le anoma hiaitia idea chu bangyam ti lehi wana Nehru Vidir ina ana singtang mite ana conceptualize na wahi amau administration hi atom deu anom ngai hi chi chu anaki established saya yai legacy pen British state legacy hi tokina hi talk le constitution na le hi yai preservation le protection mechanism hongom kya why preservation le protection mechanism pen a philosophy pen ka yet chen hi amau hi ya mi changkang zo sumdong siam zo ki well organized zo te to compete changa ban zo lo di hai chana amau cultural life a language le agam te hum bi thi na dia amau de administration tuam ngai chi ahia hilele waitan tungma ithe diu chu bangyam chi le singta mi te bangin le hi historical past to hi koi tanya mina ina romanticize lotelwa kachidia and maybe since this is an academic platform maybe there has been over romanticization of our historical past and institutions but then what we are not scholarly looking at it is that a customary institution, particularly institution of the chief being it has already stripped the institution of all his powers and glory and amasain let's say Saptio Maina chief as a sovereign chief dana chief pan ting bang le na provide a protection le na pia mana by protection thina dina vassal system feudal system dan de wina taxes bang le anala waite ithe le state hongom chani state ina chief pen a power le hong ki strip ta a glory le hong ki strip ta bas an agent of the state and hon chani why pen romanticize in he koi tanya mina adia evolution of the society bang le on impediment khamai thea hilele yai kom ka la hi dena in against sama boni constitutional protection for tribal ways of life and culture tradition customary institution thina dini yai 6 schedule provision hongomahia and sagna dina article 244 anoma article 244(1) penin hi 5th schedule lamagena wana article 242 penin hi 6th schedule concept lam ahon genona yai article 244 le article 275 clause 1 ongkila khom chan hi 6th schedule provision hongom khia ahia a 6th schedule yon gen chan hi 6th schedule ana study khaten hi athei diwa 6th schedule hi district council concept homana para 3 honga wana regional council concept hongom nona wana para 4 hi with regard to administration of justice china para 4 anom nona wana para 5 hi administration of justice where the issue pertains to imprisonment of 6 years plus on here le murder le death penalty on hi chani rule hong to among te hongoma 6th schedule a beauty to bangyam chi le hi then article 275(1) ziakini consolidated fund government union of India apati funding omthei onghi naini financial power on newa wana because of the very features of 6th schedule article 244 apat hong kilak chana the union legislated laws may not necessarily be applicable in the 6th schedule reason here why pen alternative the bangyam chichani the 6th schedule district councils and regional councils have a power to legislate chi hong here why again article para 9 honget chani money lending rule bangom nona para 10 bangyon det chani related to social custom lineage ti kong bang le why apat a power hong kila why jakin hi why lo ina para 3 lakh hong hi bang chida na shop regulations use of land etc fisheries etc why legislative power on ne chana a legislative power le executive power le judicial power on ne chana it is a very potent institution would actually help the tribal communities to self-govern why concept pain chang takina hongom ketheya Manipur case hi we are under 371C ahong here 371C hi icha ion det chani 371C pe ni yayin hi an idea of creation of a hill area committee hongoma and then what it simply says is that governor in an NKD kumtenga khatbe bek report la president kyanga sunglut jail de wailo ina hill areas are politician te hi by being by them being an MLA, they also will be member of the hill area committees. Anachi, ahia, why hill area kipuana diongoma wana a district council kipuana delay. Ahongom nona, why pain, 6 schedule chatchu honginon kea, why naksana, it is very different from the 6 schedule. Manipur administration pain unit non chana hill areas bangai administration of hill areas are carried out by DC concerned who on the other hand as a district magistrate act as a district magistrate who would support of the district level officer and block development officers china administration pain onki po kenona wana hill areas district council act 1971 hongom kya kini a criticism achu bagam chile it is a toothless legislation because it neither have financial power it neither have legislative power neither it has executive power or judicial power hichibang thilongom chani ilagwa bang le I customary laws le institutions te loi enchu koi tanhamina bang chetukin effective law sa bang ilele ihon dan ihon boldek chani state level state thepia why a power dan bola le accountability ihon create inadi why dana omlo mo ai chani it becomes a very far-fetched from the idea of the idea, principles, and values with which 6th schedule was inserted into the Constitution of India. Why da nangam kanonai?
The nanon gain ka interesting ka sama toothless legislation na chika hill area to kisaya chu I paid ma hi awai zaka to chu if I to keep ana hi chianga kha we should go till the end to get separate administration ya ya chu why kha permanent solution hi le chu de why pain ahi ya ke individual ngai twa dan ina jak chu asamale BTC Bodo Territorial Council om thele chu why not in Manipur chi kha ka ngai twa nang po ta mo Kuchi keile chu to adena na chi banga executive legislative judiciary power bang ma ki nei lo financial power le ki nei lo hinchin next question kon dot ma in den cha attendees ten kha hun question dot na di hunna dewa na nei wale den cha towards the end of the talk huni hong diwa tulela Dr. Khup separate administration ichi changa kha to very lucid hoi takinon explain akipa hwaya to ale ke le ko na ba ka masa chu en le banga idea ona kini hollo mo why here hollo happy takin heu tu pa moanin kha I question te kha den cha I heu tu pa question ong pai te kha happy takina na note down hen la aman den cha question answer ama khutin konpedia hiai iboi na to ki saya kha separate administration bangle hoi takaon genta china then dena Supreme Court hearing bangle theibe tampi yo o minjin khatvei kha WhatsApp group khongai cha akwa kwain kha na na wa zero FIR on file on a file chi khong cha kha message khongong pai akwa kwain kha ki hil twain jin zero FIR chi changa kha FIR dang to banga awai FIR naran chi to zero FIR akibat lo na hia while a implication banga zero FIR in kha bangtan on tun dia chi kha I happy takin hai tungtanga on hil chang theile chen Dr. Hu
ole zero FIR hi tunai je ka Delhi Nirbhaya case થઈ ગયું છે ને મલે Nirbhaya case ongo male hi jurisdiction issue hongom kahia why lo wina Hathra case bangle hongno na Nirbhaya case hongom nung hi Justice Verma committee kichi hongoma Justice Verma committee hongom in hi zero FIR apoi modan hongki gena wana wai Hathra case hongom bangin lehi zero FIR a jurisdiction issues yakina apoi modan bang hong changno na zero FIR chi chan hi CRPC 154 noya hi section 154 noya hi any kind of a crime which is it due to IPC substantive law noya hi cognizable non-cognizable offenses differentiation ana oma it's anadina cognizable offenses something which is of serious in nature essentially rape robbery murder theft etc here cognizable offense warrant apoi mo kaya police bangin lehi as per information received if any person is accused or alleged to be accused why he matena power honya wana non-cognizable offense on kichi chan hi petty theft kong forgery kong public nuisance kong ya te pen hi police in general laibu to am khat oma general diarrhea chu waya ahong ki get luta dena cognizable offense in again murder yam robbery yam rape yam chi section 154 of the criminal procedure yai ichibang thilongom chani FIR file di chi hilele khen khata hi police in hi jurisdiction issue hong aum chani FIR a file nuam kya why jakin hi the FIR le zero FIR ke barlo na chu FIR is lodged as a complaint by informant where the incident has occurred in the area in which the police station has jurisdiction to conduct an investigation, whereas zero FIR can be lodged in any police station irrespective of incident happening anywhere here. Why is that to pau siam pai pibang ini zero FIR bega na file na chiwi internally displaced yung hi khakphot chan hi iting namun pen le iwa om namuna haksat na iwa tua pen ai kele min hon bol siad na penu why mun chata why police jurisdiction na FIR va file theino lo hi chani itai namuna hi zero FIR file thea ya wana a purpose ka bayang chile to avoid delay in any other kind of disruption kadaya to make police bound to take the jurisdiction kadahinona timely jurisdiction to be taken immediately after registration of the FIR here to make sure that the investigation is done properly hinona and to enable the case to proceed faster here. And Mudanchu, zero FIR is more efficient and effective way without facing any hassles and inconvenience while registering FIR and the police. Here, who can file an FIR? A zero FIR. An FIR can be registered by the victim himself or herself, a family or relative, or any other person who knows the facts relating to the incident can also file on behalf of the victim. Ahia, wana zero FIR ento non bangilehi. Steps to be taken. The nature of the offense must be cognizable. Cognizable offenses rape lehite, murder lehite, communal writing lehite yonginona. Wana the information can be submitted in written, whereas the information is given orally by the informant, then it must be reduced into writing and read over to the informant. The copy of the FIR is given free of cost to the informant. Section tampi omnona numerated related cases bangahi. Section 154(1) a issue pen numerator kisayahi lechu. Then police officer or women officer will register such information. The entire information is videographed. Section 164 CRPC statement piakyam leadang dang te. If the police officer denies even to register a zero FIR, then the aggrieved person can write to the superintendent of the police, and still if it doesn't work, then he can send a complaint to the magistrate through an advocate. The advocate then zero FIR file dia chiu lechu yai pen inangai sudwa poimo de umaya persua FIR hi in a file poimoi yaya zero FIR alim kon ko ikya muteya aneula sim diama zero FIR hi first information china ana atunga kigel dia waya ano abanai a bracket zero FIR kijidia wana noya hi under section 154 CRPC akijidia wana district konga mina akipia wana police station konga le kipia kum konga kipedia wana ax pen bang IPC provision noya omaya ji kong wana occurrence of offense via chain of events le dang day I could date from ji kong wana type of information oral here written here ji information akipetheya wana a complainant mean nationality dang kong le akipetheya jana details atwam oma ya atopa hi first information report zero FIR cha kigel de vaidana omai zero FIR hi wailowa yai offenses to to aina to akha hi koi tanya mina religious offense le anahia wai jakin hi ya religious offense hi IPC no hi 395 le 295 to 297 IPC ana kidila wana defilement of places of worship of objects yoma worship or objects of veneration yoma wana outraging or wounding religious feelings of person yoma wana disturbing religious assemblies yoma to ken khat bang viral video ir khakti hoi biakin avalun hi simmo takina avalua pahoi lo pi bang le anazangwa wana no singtang mi te hon subchimit diu kai chi bang na akiko wa hei tiba lehi evidence hoi mama onginona defilement offenses against religion noya hi wana arson cases bang hi 435 to 438 noyoma wana mischief destroying of landmark chi khom bang le ana omnona wailo wina apoy mo non chu ST and SC Atrocities Amendment Act awma yai noya hi section yahi 1980 za ki act himare 2015 na ki amenda section 41 wa yahi yaya provision khen khat bang esana da a din munto ki kitwa kaya forcibly whoever not being a member of scheduled caste or scheduled tribe forcibly commits on a member of scheduled caste or scheduled tribe any act such as removing clothes from the person chi khong forceful tonsuring chi khongoma while wina wrongfully occupies or cultivate land of a tribe chi amno na wana wrongfully dispossesses a member of scheduled caste or scheduled tribe from his land or premises or interferes with enjoyment of his rights chi bangoma including forest rights over any land or premises or water or irrigation facilities chi bangoma while wina institute false, malicious, or vexatious suit or criminal or other legal proceedings against member of scheduled caste or scheduled tribe chiomnona. Wana gives false or frivolous information to any public servant chi bangoma. Wana cause walo wina yai apopoy mo kat non kana sakchu STSC Act no yahi. Esa na dia police kat bangin a duty ai di banga hi nomlo bang hitale why provision banga lehi as another the public servant not doing his duty section 5 subsection 1 why anoma yai to galdo hi state khat nam tom chicken nam bing khatin do hi nawahi public servant bangin le on a support hoi lo chi bangom the so that zan hause kina tangkhul te numeni airport a paidek mi bang zema na manwa na soisa waile officer khatin hi spokesperson khatin hi chibang incident omlo hi china false ai china ana the khemoga why jakin hi dena atrocities atrocities act section 4 subsection 1 close to te hi to idin mun te yo chani medite ST hinalo hai jakuni in apat lehon hol khiawa a place of worship colon defile sakwa wana inumate bangle janal baina civilian law hilele an attack wa pana ku bangana kai kek sakhawa wailo wina police te bangin lehi a duty ai dibang bang una an he kyo cha ion ya chani dan lampang chu ST hinai le constitutional protection le special laws on ki enact jakini adin chu pangsiamina advocate jangsiam le evidence nei teu as a evidence hi evidence act ki chi khadomai a fact which is claimed has to be proved here section 1110 here my evidence act ai yai ki che ja ki ni mean kai na pat hon dispossess ai mean ka inhon sar syak sa kai mean kanumei te hon bo siawi ai ke officer ken khatin kon support lawai chi le chu we have to have at least video evidence or maybe some kind of evidence to prove our points. To substantiate our claim, we have the substantive law of the IPC and then the special law enacted for protection of ST Act. Chibangle hongomnon ai.
Tunka rights tampia ki thebea FIR file dibang. Ahi kele na again twa zero FIR bang. Uchile doctor ko zero FIR tampi file e case ka on panpi thediam will it help us in our case si pongbang ongoma onnon dong waldiam
denaka chima banga mo our cases have to be genuine Our cases have to be genuine. Why jaka a genuine sufferers, genuine victims. As another a langol hong, new chekon hong, haukip veng hong, le mundang danga ma a anatwa ko mawai tu. Anatwa ko muntin. Why techu to a langol police yam, lampel police station yam, le dang dang tia case file the no lo mawai tu. There's no chance because they cannot go back because there's a risk of their life. When your MLA himself is not safe, or the MLAs do not themselves feel safe, common man is not safe. That's the understanding we have. Why zero FIR pain idea to bayan tile. Because of maybe some political situation or maybe societal dynamics, as another Hatra case bang tunai jega UPR that incident, it involves a lower caste and then upper caste Hindu people. Why case bang janga? Why a jurisdiction pena a police ten co-jurisdiction hiloway hongki no lu janga. FIR hongki file hiloway jana. It hampers in the investigation process. Here, why jaka any genuine person who had been a victim of the ethnic mayhem that has happened till now, wherever they are, they can file for a zero FIR. That will be routed to the relevant jurisdiction. The idea is that to whichever police station that they have filed, at least since it pertains to cognizable offense is any offense whereby the punishment is more than 5 years. Robbery, theft, murder, arson, property damage, to an extent the volatility of the situation, attack on the person's safety and causing grievous injury and murder, etc. Why cases they zero FIR ki file the.
Da karkhat bangwalta insin I theuta matam lai hilele I Wagain genle zanko wagyong hi thei mo there are so many aspects of law. A section banga 1275 244 371 can to banga the thei na kha ken kha I really admire chi kha kon gen dia one last question for the day. I thei utam piom lai le leke ya ki pat question last question kon dong dia. Why hitja heutu pa muanina banga attendee ten question banga neile aman ka why on put up there. Eikha eternally displaced persons tam ka eternally displaced persons bang ki omta injin. Why ti adia rights illegal rights omte diang.
I can show them more. I'll just show one thing. I have a slide on that. Refugees versus refugees kichi mo. Different categories of people are there. Refugees kachu we have Geneva Convention kat anoma mo 1950s you know. White Tenchu, they have protection, they have the international law related protections mechanism, etc. They have. While internally displaced people we do not necessarily cross their country and move to another country. They here huchibang din muna omkhateha. Because it's a internal state matters of each other. The sovereignty of the state is taken into consideration, and internal displacement can happen because of maybe communal violence, etc., etc. Here, law and order issue of the specific state on each other. It may not necessarily lead to a legal rights because you are not a refugee. No. Have you crossed over to a different country because there was ethnic cleansing in your state, and therefore you have taken shelter in a separate country which is neutral. State Hiloina. Mizoramai Vataipian, India Sumba only Jani, internally displaced only Vavia. Ana Guwahati Vataichale internally displaced Yonghi Jani. We may not necessarily have certain rights, but then we do have our constitutional rights. It was very pertinent that we know what are our fundamental rights more. For example, right to life, Article 21, right to freedom of speech and expression, Article 19, and to move anywhere in the country, right to freedom of religion, right against exploitation, rights they and since we're under the protection and care of the state, even if we're internally displaced, our fundamental rights are very much intact. So therefore, maybe certain communities have violated our rights. So therefore, Supreme Court by an observation, this is a humanitarian crisis. We want a status report. Status report, what they asked was, how are they rehabilitated? How are they being transported? How is the state ensuring that they are transported to safety, and also provisions for them in their shelter homes, food, etc., etc. A fundamental rights being key and a. So that is where we differ, and we differ. Our case is different from an idea of being a refugee, because we are plain and simple internally displaced. Aki interprets in the context of yeah.
But we still have our fundamental rights
Yeah, we
intact.
Yeah,
Why we can always use them for our protection, no?
Yes. Article 32, Article 226 noyaka. We have a right to writ. The idea of right to writ is for the protection of fundamental rights. These are constitutional remedies.
Interesting, Mama. Banga refugees to IDPs ka banga the how you brought out the banga aspect of someone being a refugee and someone being an internally displaced person. Interesting, Mama ke pahwaya tuna burning issue tekha Yaitan ini hipot dia burning issue adang lechu tamlo la hileka chima banga. It's almost 1.5 hour. Tuna heutu pa muan ka kon samdia. I question kongom here heutu pa dot kongom.
I chat box check dile ko I ni jo mo Dr. T Langel namu ya. Hai tigeran makat perle.
If the executive powers consider as the demand status of Meitei when that Meitei case ka hoita ka amount na study hinunsin. Kinle I studied their case. I studied their case, and as soon as they Meitei na hiling. They do have very convincing arguments. They really have convincing arguments. A side, the saving grace is they also admit that they are more advanced than rest of the tribes in Manipur too. They accept that. They know that they are more advanced. Apuya still he evolved onto. They have an idea of governance, they have an idea of administration, they have an idea of judiciary, they have an idea of medicinal knowledge, etc., language, culture. Why Jamali advanced Kisama Ahiwa. And like it was already said, amau concern ha as another top bureaucrat pen may te hilo chibang yahi amau kama na asagaya why te sanga na asagzo kuhi why are we boxed in a 9% of whatever the territory of Manipur is chi yahi na asag ma mau ya why jageni yahi layers to amuma. One part is revival of the Sanamai, another one is using the Hindutva cards di Bangle. It's a mixture of many things. So jaka a meitete case pain from a external observer point of view at Banghilehi. They actually belong to a very different racial stock, which is like a Mongoloid stock. Apaupe no Tibeto-Burman idea, I don't know. I'm not specialized on that. But then they happen to be topographically in some idea of a landlocked area, which is cut off from the context of a larger mainstream India, and plus contact with rest of the world, whatever idea of mainstream India chichani, it's to an extent is limited, and therefore those features of being a tribe and being an indigenous person, they all have that features. Why Jakamau writing hon etet chamni whatever the historical past of maybe terming Singtamite as how or Nammang Achiu Banglahi, they cherry picked. They have selective amnesia about those historical past of theirs, but then they definitely remember their glorious in their whatever idea of the glorious kingdom. Why to they remember and they want to pursue that in some form or the other. Why jaga Aramba Tengol Lipun Chibang Hongwang Thagaya, and then the titular king. I don't know who it is. Is it the CM or is it the MP? I don't know. Why kikala angom nona. Ibang hile it's another question. Dangahi adangom non kima.
Hatwaya en langilin anwaya scroll suglesin 0 file ka online file thedi here.
Zero FIR ka online file thelo. Online file thelo. Tu tadi aja mo. Zero FIR pin ka. Why it came out, the concern was that cognizable offense can cut the jurisdiction issue or cut nai by appeal wang nadia zero FIR by hindrances to overcome nadia 0 FIR consequence kia
Anwaya biakinon dokhalo mamo kumna muya
ha
last pen
ha pen Justice Verma committee in a amendment of the criminal justice system why report na piaga why pata ngom kya
chiang media maya I lal mangai hauzel in la khatun dong no na to 0 file chiang a section tom na hon gen te kinei theile for reference patoma ma ding ibe achia
it due to cognizable offense demo rape murder grievous injury any cases where the punishment is more than 6 years and above why cases stay
okay ai le kei apat don of khat kun ne ya I to ko wa I MU to ki sai bang I sing tang mi chini cookie zo mi te on tek de kwa hostel teng bang le kaban teng bang le social why ki changa faculty teaching tonon teaching staff teng in teng man social mo ban teng hi siao ai bana tu da dia kha scholar Eimi sing tang mi chini somsa gi war bang PhD kian rolom ai bana master simlel zali le chi lakom azo teaching staff tonon teaching staff bangle som ngalam khong ke phadi ngoi teng teng kha tai gai ka hiwa mun tom pe kamo pass polam to kwa malum non ke ya ai le to ki sai ai legal lama bang chi pan lang ding ka hiwa ko Eimi mountain
so it's another the provision khatchu STSC atrocities act noya mo azia to ya me te kha ST hinai lo photuive why jaka dena provision section 4 subsection 1 E F G H atom to bom te mo why te la ka ina to khawdan dana by provisions te bang ile while lower to ya no na to pin che tu kha cognizable hi na dia did someone injure the other person grievously so there can be a isolated case of someone being brutally attacked and grievously injured. While it's a cognizable offense. Another case is that did they rob you by using guns or maybe any weapons which in your apprehension causes the fear of life of limb? Then that's another cognizable offense. No, so whatever cognizable offense in such a scenario, you have an option of a zero FIR. So the zero FIR can be filed at wherever shelter you are taking. Presume bangile. Why jaga to awai Delhi siam phai pin Twitter hiam bangja hiam na kapya kya kindly file FIR vachi pin. See, one part is I can file an FIR, but then is it a cognizable offense? But then if it's a cognizable offense, then we could have an idea of a team, maybe a civil society organization, or maybe a human right activist, group of human right activists. Why good as a class suit, as a class issue, maybe depending on the gravity of the case, some zero FIR could have been filed. Why on here too? As a arson here, yon getable IPC a punishment ka 3 years, 4 years. Hong here, defilement of church, place of worship. Why this jurisdiction issue is a matter of grave concern. A zero FIR it limits the applicability of the zero FIR on cognizable offenses. No. Why that STSC Atrocities Act Bangale, many of the issues are like found to be, and that people have been targeted because they are how yonji changa. It's a degradatory term which loosely mean impure slave. So that's degradatory. So that's there an SCST Atrocities Act is relevant, but then it may not necessarily be a cognizable offense. So where is the jurisdiction? This is a very peculiar scenario. Rehabilitation will I be able to go back after seeing this? I may not be. A complaint when what would be the limitation time? 2 months, 3 months time? It's a very special situation, an unprecedented situation. Some kind of a writ petition filed because you lose your right to education, Article 21A, your fundamental right to education, and because of a right, and also you were targeted because you were a tribe. The fundamental rights getting violated, so you have maybe an option to file a class suit with regard to certain writ petition because grave injustice has been done.
Tua tamzo ko moban sini ko context me ya tamzo bang chu ki no lo te bang career bang boy tam PMD tam mo oi bana a certificate abang teng bang ki hal zo malai athil teng to nange dan ST/SC atrocity oi ek noya kha panlak thida na bang khade mo FIR file masaka
but then it's not a zero FIR there why jaga nang Manipuram lo jail nai chu why cut your other option is fundamental rights have been violated why jaga writ petition as a class suit bang ne that option can be explored
to bang chu gen lai let new chik accept na nei te bang le professor ina kwa teng bang le te ke na nei lami the deu associate professor pum khan pau jang mang chi te loi bang le cha tai mang bek mo sem teng david ke zo te bang le personal of te ama kha join register hin chen le escape khajen jena chu ma ba na hi tin chu panla din ka ging ta thawa
special leave petition article 136 option leon and then the Supreme Court in Article 142 for greater justice aleka original jurisdiction lela the so why jaga why gang me MLA to acho man la withdraw ta why hill area committee chairman pa petition bangle SLP because an idea of grave injustice has been caused to a certain community more so why jaga Supreme Court in we are keeping this matter pending at IIT's right.
Okay. Also, hen khat zero file bang file thelo min sin ki ko aite bang si panlag de a Delhi context bang si di.
Ana accept gulo. Na chi banga nangbang in zero FIR file bang ilete. Nang lamka na lomom nagle lamka police station who is aware of the facts of the issues and then the factual even why nang tanga na sakte chi mai chu option mo why jaka mi khat chawin money case and then when he is a victim himself hak samai chu so ken le kha na ngai to khaenga what I learned was we need human rights activists we need some kind of a human rights law network a forum kat a matter analadi is that there's some pipe bang in gain secretary and he's very concerned he's very concerned but then why kaita mi khata ihon yat suk changa nang police station of a paichina vaite khat bang in even if he's a police officer no jurisdiction ne hoga anachi mogle how do you counter that strong assertion in a place which is so alien so therefore Mediterranean judicial war and anachinamawa we need a collective platform which is going to pursue and see these matters yai khat ngai why jaga consultative yam bangyam mong jagbale there has to be a team which look and work into these matters more and the matter should be genuine matters take a genuine thing quite same as a frivolous is going to collapse it's going to collapse yai khatom non mo why is a cognitive offense khau hoi taka I thei chatu kha hoi
to iboy na to kisai he tu tom til jo panana nang apat legal lama bang chi pan lag le yai to I political demand separate administration ya ke state ya ke le greater Mizoram ya backup thi din legal lama bang chi pan lag le hoina sa tamlo non kum thei dia
tunya why Amit Shah honorable home minister in again kha a meaning thu gina kana the ya Manipura ni thum kom dia mo waya a issue te banga chi ka the siam som dia wana BJP sarkarin le Narendra Modi government in ai the hi de chi ilele finally a peace kha it is for the people of Manipur to decide how they are going to achieve their peace here to in EMLA Kwatin on Getui for separate administration Kichi. It is purely on ethnic line. Ethnic line on each and Haipin central government in Bangchanon Indiam Chichu Akite care. Why Zaka what is most achievable? We are not sure yet. Why Mizoram context bang non jani? It is an internal affair of another state hongin on more. Hilele why zo ethnic affiliation pain Mizoram Sarkar in hon ha etchechu. On that line, it has to be the idea has to be respected. Hilele International Covenant on Civil and Political Rights UN on Indigenous Peoples' Rights why the protection of culture, etc., of whoever is indigenous or a minority a concept nona. So while lampang ayon that non chechu the state though they may claim as minority, but then within their own state there are other groups who are minorities, and that has to be recognized. A concept le non and then what also is that 371C is a union enacted provision more, and plus when the Autonomous Hill District was first enacted, Manipur was not a state yet. Let's say so. It's a centrally enacted legislation. Maybe it's a government of India can maybe ensure maybe a special packaging as per the 6th schedule dana 275 dana consolidated fund direct fund more, and plus maybe make the 371C provision more effective with powers of enacting laws and then powers of executive and then judiciary. Why don't you cut a package in both? Then maybe there is that option might be more achievable or attainable. While other options would lead to a very long drawn process, I think maybe it will not come. It will not be an achievable aim or ambition which can be grabbed so easily. It's going to require lots of sacrifices and preparations, I think.
Meditesti demand ya to bang khen khaten ST demand pen so ma pai na pai hen la na yai constitution to banga ana protect na hi chi bangomin sin to wai meditesti demand pen kha bu pi bo lai di ai ke le hu me na pai ho ju di ya ai pai ya pai nang ngai nan bang ya
meditesti demand le bo hoi ngai su hoi ngai because amau SC no ya le reservation nei mo OBC no ya le reservation nei u baga economically backward no ya le nei u, and then they are general again, so the pie is so big. Why Zaka so at least there can be a bargain that what happens to those affirmative action and protection. This is one. If it's inevitable that they get an ST status, idea to if they have an ST status, then they are plain and more advanced more. So therefore, the Hill track are, let's say, 44%, and they being close to 50+%, or maybe Hill people are 34%. So how do you work out the reservation criteria in the state of Manipur? So that has to be very clearly worked out, and there has to be an idea of creamy layer. Creamy layer with the establish. A problem mama chu. they see the recognition as a tool and a means to access the hill areas. That's a problem. A problem is why deep-rooted hatred on pain. We are being boxed to 9% of our land. Hãy biến hoa gầm đây luật giặc cho wa vậy và đây luật ta hoa alam piom khát te dong khol sa hi chimid đi sắc biến ka problem nói chứ vậy giờ cái IST biến leong problem kanon bang sim no hãy cái cal amao bang leong balance theo leu chứ thu khát ile thil khát non lag dek pin na justification kha hiya ile na tuk pin kha mi suk chai hiya ma wai valag di chi pin hongi chang chu a motive le a intent pin kha it looks very dangerous, and we have seen the outcome also.
Ai jangan dikira apa progress ada teng nang kota unmute
unmute kin ha tu ni kha anop lopet ma kachi ma wanga issues tampi leilung sima omdi I dotuleta matam kine lai hilele chi ma wanga kha dakar ni bang ong pha phialta insin tu nin kha yai hun sak yama ba na le tu ni resource person u Dr. Khup kha ki phalgi ge kachi ma banga bula introduction ka ne la ya kha non som hun na kha ke mandi kahi ki man sak di kahi chi kha ma kha banga legal expertise lam kha ipoi mo nagle ma kha mangi ge hi ya wai tunga le ma tunga ki pa thu ka ge na paite academia forum sikletangina Dr. Thangzakhup Tombing tunga ki pa thu ka ge na na expertise tu ni bang thiltam pi ki thei be a na wa khwai ma ki pa hwa ya I wish you many more success in life, Dr. Khup.
Thank you.
I like to just say a note of appreciation to ni Microsoft team ai itok nei na dibang twa paite academia forum sikleta nga kha Dr. Muan Guiten kha Microsoft team license le hiya Zoom khong Google khong hile chu dakar khat kan ki jang thelo di tu nya chu nok taka Dakar ni bang pha phial mo wai zaka ibanga tu lai taka burning issue te bang hun khop tak ki discuss the hiya Dr. Khup le heu tu pa muan tunga le ki pa tho ka ge na china tu ni kha huni be sak jama ba na le Dr. Khup mangi ge hi na we will keep in touch, and thank you so much, Dr. Khup.
Thank you so much. Thank you all.